First of all, I just wanted to welcome everyone. My name is Kat from Peaceful Presence Divorce Coaching, and welcome to the first ever Lunch and Learn event. This is going to be a series that we have normally twice a month, once a month in November and December. You're going to hear from tons of different experts in lots of different fields that are going to give you some great advice on how to rebuild and heal and navigate the journey of divorce and family court. So I first want to start off by welcoming our wonderful guest speaker, Ashley Adabahr. Ashley is a licensed legal professional and family law mediator with Two Roads Licensed Legal Paraprofessionals. She's located right here in Colorado. Ashley is licensed by the Colorado Supreme Court to practice family law, and her work focuses on helping clients navigate divorce, custody, and post-decree issues in a way that's practical, empowering, and affordable. Before we get started, I just want to let everybody know that we want this to feel like a conversation. So feel free to use the Q&A and the chat feature. We have our lovely moderator, Shruti, who is going to be helping us manage the Q&A and the chat feature today. So if you have a question that you would like Ashley to answer at the end of the presentation, just put that in the chat box. And just a quick reminder that we are recording for those who couldn't make it live today. So Ashley is going to walk us through the strategy of leveraging unbundled legal services to save you money. Ashley, thank you so much for being here, and go ahead and take it away.
Thank you so much for that introduction, Kat. As Kat said, I'm Ashley Adabahr. I'm a licensed legal paraprofessional, also a family law mediator located in Centennial, Colorado. Prior to becoming an LLP, I was a senior paralegal for a divorce and family law firm in Colorado, down in Denver. And I worked in high net worth and high asset divorce cases. I was part of the first group of LLPs to be sworn in by the Colorado Supreme Court in June of 2024. So I have been practicing for a little while now. And in February, I decided to start my own solo practice. I'm also collaboratively trained. So I work a lot with clients who are trying to achieve amicable resolutions in their cases. And I'm on the board of directors for the Colorado Collaborative Divorce Professionals as well. Oops, my apologies. Okay. So before we get into, the topic of the conversation today, I did just want to start with talking about what a licensed legal paraprofessional is. I know not all of you are joining us here in Colorado or from Colorado, so I did want to point out that this is a program that does exist throughout the country. It's not necessarily called licensed legal paraprofessional in every state, but there are iterations of this program across the country. So if you're here in Colorado, this program is pretty new to us, like I said, June of 2024, but I just wanted to explain to you sort of what we are and what we're not. A lot of people have sort of a misconception that we're paralegals, which is not the case. As Kat said, we are independently licensed by the Colorado Supreme Court. We actually practice family law in Colorado. We're not attorneys in the sense that we didn't go through their bar exam or law school, but we do have significant experience in the practice, of law as paralegals, or through educational experience as well. And so we have gone through our own family law bar exam here in Colorado. We've also passed the character and fitness examination that's required of all attorneys. And we do carry generally malpractice insurance. And we practice, like I said, fully independently from attorneys. So we don't require attorney supervision, and we don't have to work for or with attorneys in our practices. The one thing that sort of differentiates LLPs from attorneys is that we have some limitations on our scope, and we work only and exclusively in family law. So there are certain issues within family law we can't advise clients on. It doesn't mean we can't work with them in their cases, but it means there are certain issues that they come up, they have to be handled by the client or by an attorney. So I just highlighted here on this slide the first or the rule that governs our practice, so that if you want to take a look, you certainly can. I mean, if you have questions about what LLPs are, you can visit the website link here that will give you some answers to those questions. But I did just want to point out that this is not exclusive to Colorado. So if you are in need of legal services from someone other than an attorney, take a look in your state and see what you guys have available. So I want to talk a bit about what unbundled legal services actually, sort of are and how they work in a case versus full representation. So Full representation is the sort of traditional model of divorce or child custody cases, right? You go to a law firm and you hire an attorney and they represent you in every aspect of your case. They handle the day-to-day communications with the court, communications with the other party, scheduling, drafting, filing, everything. And that's can be a very expensive process, as some of you may know. Having someone that you have to pay on an hourly basis to handle every single thing in your case can get quite expensive quite fast. So unbundled legal services are a way for people to receive legal advice sort of a la carte on specific issues or in specific instances without paying an ongoing hourly rate for representation. And I do want to preface this by saying that it's not just LLPs that offer this type of service, plenty of attorneys do as well. But I do sort of talk about LLPs in my presentation because that's what I do. So just know that if you see LLP mentioned, attorneys also can provide that type of service. You just have to check with them to see what they offer. So, clients are allowed to sort of select what type of services they want in this type of representation without incurring costs for full representation. What that usually means is that the LLP is not entering their appearance on your behalf. Sometimes they do. If you've asked them to attend a hearing with you, for instance, they may enter a limited scope appearance. Generally, cases that I work on, I don't enter my appearance in the case at all. So I just help the client as a background consultant, and my participation in the case may or may not be known to the other side. It might be that my client just calls me with a few questions here and there that I answer, or the other side knows that I'm working on things in the case. They may also have an unbundled person on the other side. So it's a bit different in the sense that you get a little bit more control over whether or not the other person sort of knows you have representation, and sometimes that can keep conflict down as well.
Awesome. Thank you. I was just going to say, go ahead, Ashley.
What was that, Kat?
Well, I was just curious, as part of your process, when you're working with somebody with unbundled legal services, do you train them in the beginning if there's things that they don't know how to do initially, like how to submit a filing through e-filing systems, what typical response deadlines are? Is that part of your process?
So it depends. It depends on what the client's looking for, and it depends on where the case is at. So sometimes clients will call me at the beginning, and in that case, yes, my goal would be to explain to them what the process looks like, how to get things filed, and we'll talk a little bit about that in terms of case analysis in a minute. But yeah, part of it is, how to get your case started, how to set yourself up for e-filing, what are deadlines. Deadlines do differ for a lot of different things in a case, so it may not be as cost effective for me to sort of start with that in the beginning. They may just want to know, what is my deadline to respond to this motion, for instance? What does a typical timeline of a divorce or child custody case look like? Things like that. But yeah, a lot of times it starts with, how do I file my case? How do I get the other person served? And what do I do next? So that's a pretty standard starting place. And then we kind of talk about deadlines as we go through the case.
Perfect. Thanks.
So some examples of unbundled legal services I kind of wanted to call out. So all kinds of different LLPs and attorneys offer different unbundled services. I have a fee agreement that I send out that includes a long list of different options for the client. And the way it works is, the client has to decide what services do they want to pay for and what things do they want to handle themselves. If a client's uncomfortable handling sort of day-to-day management of their case, they may be looking more for full representation. Otherwise, they may just want, me to help them prepare for mediation, for example, review documents and correspondence from the court, or just do sort of piecemeal work in the case. And so what I'll do is I'll send my fee agreement, which explains, what I can and can't do, and then offers like a menu of services to a client. And then there's a check the box system. So the client just checks the boxes for the different services they may or may not want. If they don't know what they want, they can certainly check every box. It's fine either way. And then those are the services that the client will contact me to assist them with. And some examples of that are, evaluating the case at the beginning. So I think that is really, really helpful for clients to understand, if you're coming to me on a divorce case, you can give me an idea of what assets we're dealing with, what debts we have, is there separate property, whatever the issues are. And through that analysis, the client can kind of figure out what the sort of range of potential options are, either for settlement or litigation. And I think that can be really helpful for people, because a lot of times people are just walking into a case without really knowing anything about what their legal rights are. And sometimes that really results in, especially if the other side is represented, that client might be kind of steamrolled in a sense, where they just have no knowledge. And because of that, they end up with potentially a worse deal than they otherwise might have gotten. So that can be a really good use of your resources, is to just get an idea of what is possible for you in your case. I also, like we were just talking with Kat, provide some guidance on procedure in terms of, where do I file my case? How do I get it started? How do I get the other party served? What constitutes service? And how do I set myself up so I can get things filed with the court electronically? And then what comes next? And so a lot of that initial process gets discussed with most of my clients as well. Or if they've been served, what do I do now? How do I respond to this? What are my next steps? And so there's a lot of that in the beginning as well. And I can also suggest documents to be prepared, or assist the client with preparation of documents. One thing to keep in mind is we do have a requirement that if we are substantially participating in drafting, we do have to make our presence in the case known at that point, in terms of our helping with the drafting. Otherwise, I can point clients to documents that they should be preparing, and sort of help them with some language and suggestions and things like that.
Got it.
A big area where I really think that you can get a lot of benefit from unbundled services in your case has to do with consulting an LLP or an attorney unbundled on preparation for things like settlement conferences or mediation. If you are in Colorado in a domestic relations case, unless there's domestic violence issues in the case, you will be mediating. You'll likely mediate during the initial case. You'll likely mediate if there's post-decree issues as well. To me, mediation, and as a mediator, I particularly love the concept of mediation, but it truly is a place where I think that you should be able to get a resolution, even when you're dealing with a high conflict case, as long as you're really well prepared. And so I think that's an area where, if you have some resources to spend on legal services, preparing yourself for that mediation process is a really good use of those resources. As an example, I had a client recently in an APR custody case, and the other side was pretty litigious. She wanted a change in the parenting plan that was substantial, and didn't really know how to achieve that, right? And didn't want to litigate. And so I spent extensive time with her preparing for that mediation, helping her to come up with sort of retorts to the arguments that he had made, and really prepare so that she could communicate with the mediator as a pro se party. And at the end of that, she got what she wanted. She got everything actually that she was asking for, because the mediator really was able to help her facilitate that conversation, and because she was prepared. So I think that was a really good use of her resources, and now she's not going to litigate those issues. So just as an example. And then I also help clients with things like reviewing correspondence they get from opposing counsel, figuring out how to sort of respond in an appropriate way, or how to interpret an order from the court, what deadlines are sort of associated with things that have been filed, and everything in between. So these are just some examples. There are a lot of other options as well. And one thing I want to point out now is that very recently, as in the last couple of weeks, the Colorado Supreme Court has approved rules changes for licensed legal paraprofessionals in Colorado to allow us to now litigate cases in front of the court, which prior to December 1st of this year, we have only been able to sort of assist clients with litigation, but not examine witnesses in court and really participate as fully as an attorney. Well, that's about to change. So I did want to point that out for those of you in Colorado who are looking for legal assistance. You can now get either on an unbundled basis if the LLP is willing to do it, or in full representation. These LLPs can actually take these cases to court now and assist at a lower hourly rate typically than an attorney. So that's really exciting for us, and a very new change for us.
That's huge, Ashley, honestly, because so many of the clients that I work with have told me that they feel comfortable handling a lot of the aspects of the case on their own, like filings, or just sort of being in control of the day-to-day of their case. But they are really uncomfortable with the idea of going to a hearing, and standing off against an attorney, somebody who knows the law really well and who has a ton of experience litigating. And so this really seems like a high value component for people who are wanting to keep costs down, but really needing that, day of support in a hearing, because there's so many little things, not understanding when to object, when you should, things like that, that I can see being a really helpful aspects for a lot of people. You sort of mentioned this, but I did want to ask, you gave a lot of great examples of cases where unbundled legal services can be helpful. Have you ever encountered a scenario where unbundled legal services were not a good fit for the case and you would recommend that somebody go with a full retainer attorney?
Yes. So let me click to the next slide, because that's actually what we're going to talk about next. And so, oops, sorry. I just keep clicking away in the wrong direction. Sorry, guys. Yeah. So talking about who's a good fit for unbundled services. So there are times where there's most of the time for me, I think the worst sort of fit for an unbundled case is when there is a really aggressive attorney on the other side of a case who is filing motion after motion after motion, creating a lot of deadlines and confusion. The case is really just heavily litigated. I think that can be really difficult for parties, because it requires a lot of you as a pro se party, right? You have to keep track of every deadline. So if, for instance, an attorney were to file a motion every day for a couple of days, you have deadlines that are sort of rolling, for example, and you really have to be on top of every aspect of your case as an unbundled party, because you're pro se still. So I'm not entered in your case as an LLP, so I can't see these deadlines. I don't see these motions coming through. There may be a delay in you receiving them in the mail. There's a lot going on there, and those are riskier scenarios for people where I don't think that you're necessarily best off to do those things by yourself. If it's just a pro se party on the other side, you're just facing off against an ex or something like that, you may have a little bit more. It might be okay to have unbundled services if someone's really available to you, but I would say, just to jump back to what Kat was just saying before about, full representation at hearings, just remember that if you are in a situation where you have a permanent orders hearing or a hearing coming up, don't call an LLP or attorney to represent you like the week of, because there is still a lot that goes into preparing of a hearing. In most attorneys and LLPs, the reputation is on the line when it comes to appearing on your behalf in court. In general, whether it's unbundled or full representation, they do need time to prepare that hearing. So they will need to review the exhibits, potentially want to be the one who prepares those exhibits, understands who you're asking for witnesses, issuing subpoenas, things like that. So it's not a jump in at the last minute sort of thing. It still is going to require a lot of participation by both parties. But yeah, so there are some circumstances where, unbundled is not a good fit. When people call me for that service, I usually will go through a pretty, a 30-minute or so intake to figure out what their case is about and decide if I think it's appropriate, or if it's a good fit for me. If it's going to be something where they have a lot of emergencies, it may not be a great fit for unbundled services.
Got it. Thank you.
And the alternative to that, who's a good fit for unbundled. So a lot of people that call me really are capable and want to manage things on a day-to-day basis in their case. So, they're fine with calling the court and scheduling an ISC, or calling a mediator and scheduling mediation, or even communicating with the other party's attorney. I mean, lots of people are able to do that and fine with doing that. But where they really need to invest their money into their legal resources, or when there are complex issues or specific parts of their case that they really need some help with, preparing their sworn financial statement, reviewing a settlement offer, preparing for mediation, like really specific issues. And that applies to people of, I say modest means here, but there's a lot of people who really don't want to spend all their money on legal services, right? I mean, who does? So a lot of people would rather channel their financial resources into certain aspects of their case where those are best served. And also people who really need some help on a pro bono or low bono, area. Like sometimes law firms are not necessarily built or able to provide full representation for low bono clients. Like for example, me, I'm a solo practitioner right now, and I've opened my firm this this past year. So for me, taking on a lot of pro bono full representation cases would be challenging. But there are circumstances where we can offer either low bono, which is like a reduced rate sliding scale, or a pro bono service on a specific issue to just help someone who really needs it get some targeted legal advice. And then, if a party just wants help on one thing, I've had a client call me and ask me to just help her prepare a personal statement for permanent orders. Since there weren't attorneys, the parties were just going to go up and read their statements to the court and explain their position, introduce their exhibits, all of that. And so we worked together to sort of parse out what was emotion-based arguments and what really were legal-based arguments. And that was really helpful for her, because there's really a difference when you're presenting to the court what kind of information you're giving to the court, so the court can make determinations in your interest. So that was also a way for her to just spend a couple $100s to make sure she felt confident going into that hearing.
Yeah, I can see that being a huge benefit. I hear from so many people that they had negative outcomes based on just a procedural technicality that they were not aware of, that is, like nuanced family law. And so having somebody who really understands in depth what those nuanced laws are and legal options is a huge benefit.
Yeah, and it gives you a lot more confidence going into that hearing too. You don't necessarily need someone, and again, especially if you've got just two pro se parties, you're not facing off against an attorney in court. A lot of people are fine with going into court and handling it themselves, but they want to make sure that they understand, like you said, that they haven't missed something, right? So you don't want to miss a deadline to have submitted witnesses and then have your witnesses then be excluded when you really need them. And so it can be very simple things like, having an unbundled LLP review the order the court issues regarding your hearing to make sure that you've complied with all the deadlines, that you understand, if you have to update your financial disclosures in advance of the hearing, what's that deadline look like? Or even maybe just to draw you out a roadmap of all of your deadlines, which I've also done for clients, just to explain to them, this is the procedure, these are what you need to do, and then step by step, we can work through different issues as you need help, basically. And now getting to sort of the main part of our conversation is how to unbundle legal services really cut costs when it comes to your family law case. And I think for me, when I talk about, and I'm pretty enthusiastic about unbundled legal services, I've talked about this in other presentations, because I think it's so important to know that these services are available to you even if you can't afford full representation. There are certain things where it really is a good use of your resources, even if they're limited, in your family law case, to really help you avoid future issues. So getting a little bit of legal advice in your case, wherever your case happens to be at, especially maybe in the beginning, it's going to help you avoid having to rely on litigation, because you'll understand what your rights are, you'll understand what the potential outcomes could be, and that really helps you to prepare for settlement rather than litigation. If you roll the dice, which is what we sort of call it when you talk about going to court, you really are rolling the dice. You're going to litigate, and the judge can really do a lot of, it's really discretionary what outcome you get. And so by knowing what your options are with some legal advice, you avoid that sort of rolling the dice scenario. It also helps you avoid post-decree disputes down the line. The main way I see that playing out a lot with my clients is helping them with drafting language that's very, very tight and not vague. So, I've seen cases where someone years ago, the attorney I worked for had to litigate a case because the client and his ex-spouse had not put a deadline in their case to sell their home. There was just no deadline. And, the ex-wife continued to live there. And it was a huge battle, and it went to court, and it was a terrible outcome because they had not considered, because they settled it themselves, a deadline to sell a house. And so the cost of that litigation was ridiculous, quite honestly. And so, when I look at clients' parenting plans or separation agreements, things I'm looking for is everything here. How is everything allocated? Are there deadlines in place for everything that needs to get done here? And the parenting plan, is there exchange times and locations? Is there a plan B if plan A fails? What do you guys do if you don't agree? And so, as professionals, we see this all the time because this is what we do for a living. And so even just a little bit of legal advice around your final documents can really save you down the line from having to reopen these cases and address these issues.
Yeah, that's typically what we see. So most of the people in the community that I work with are dealing with a high conflict individual, which is, somebody who enjoys conflict for conflict's sake. So what they typically do is they will leverage ambiguity in your
Mhm.
parenting plan or court orders to create chaos, and they legitimately enjoy doing these things
Mhm.
to, sort of harass the safe parent. And so that's a big thing that I talk about with my clients as well, making sure that we are really tightening up the language and their separation agreements, their parenting plans, putting teeth in their separation agreements. This is the consequence if the plan is not followed. Consequences are the only thing that some of these disordered individuals tend to pay attention to. So, yeah,
Agreed.
that's really helpful.
Agree. And I think also it helps, to have that person in your corner that is really looking out for your best interest. What I do for my clients is, in the kind of cases you're talking about, what often happens is that the party who is, the victim of this sort of behavior is really just trying to get out of the situation as, safely and effectively as possible. And they'll really sometimes just say, okay, fine, let's just get this done and over with. And unfortunately, that means that they end up with these type of agreements that really are vague and are later used against them. And so someone like me comes in and I'm outside of that situation, and I tell my clients, my job is to look out for your best interest and to consider the factors that you're just not, right now you're just trying to get through it, and I'm trying to make sure you get through it in a way that protects you in the future. And so that extra language really does help. And I've had a lot of clients after I've given them my feedback say, I wouldn't have thought of that, but that really is going to make a difference down the line. And maybe right now you get along even, but you may not in the future, and you need some sort of language that allows you to get through that process. So one other thing that I think is really helpful is getting some unbundled legal advice to help you temper your expectations. And I think this is really where divorce coaches like Kat and unbundled LLPs can kind of work hand in hand. A lot of times people come to me and the basis of their legal arguments is really about emotion. It's really about how they're feeling about their case or how the other party has done something wrong. And while I fully understand that, the law is really, it just sort of is what it is. And so divorce coaches can really help clients navigate the emotional side of their case, where the LLP or the attorney really has to deal with how the law will treat the issues at hand, and kind of parse those things out. So, what I really try to focus on for my clients is to set reasonable expectations about outcomes so that they're not hanging their hat sort of on these arguments that are unlikely to prevail. So, if they really, really want to dig their heels in on an issue, I'll tell them, look, in my experience, this is not a winner, right? And so then we can kind of get down to what the real issues are and get them a better outcome. And then, yeah, just allowing clients to get really specific advice on particular issues without incurring ongoing daily costs, I think is also a huge benefit of unbundled services. So they really my clients control their bill. I don't bill them when I'm not talking to them. I don't have to bill them for things that are going on in their case that I'm not involved in. So, if they don't talk to me for 2 months while they manage their case, I'm not billing them. And that's not true most of the time with full representation, because there's always something that's happening in their case. And the attorney or LLP as a full representation advocate has to participate in all of those things. So the cost is dramatically different in those circumstances.
Yeah, we tend to see a lot of disordered people constantly pinging the attorneys wanting to interact, and that just racks up huge bills.
Yes, that's
Um,
exactly it.
Yeah. And so what I want to do, actually, we are getting really close. We have about technically 1 minute remaining. We'll probably go just a couple minutes over, but we have a couple of questions that I just want to make sure that we can get answered. This slide is really helpful. If folks want to take a screenshot of that, it gives you sort of a typical outline of how much you can expect to spend on certain things, that's a great outline. Thank you for that.
Yeah, absolutely.
So yeah, let's just dive in. One question that we had was, can LLPs help in a custody case with parents in different states?
So that would depend on there's a jurisdictional dispute. For instance, if the case was already in Colorado, and one party had moved and the kid, is back and forth or here, it would depend on jurisdiction. So jurisdiction is one of the issues that is outside of the scope of LLPs. So the jurisdiction would have to be determined first. If there's a challenge to the jurisdiction, then no, the LLP is not going to be working on that aspect of the case. If the case is determined that it's taking place in Colorado and there's a family law case here, then the LLP can work on a family law case in Colorado.
Yeah, that's helpful. Thank you. We had another one. If you begin your process pro se, can you switch to a full representation attorney in the middle? I can go ahead and answer that. Yes, people do that all the time. A lot of people will start out self-represented, realize that the case is too much to manage. They really need the help of either an LLP or a full retainer attorney. So that happens pretty frequently. Yes, you can do that at any time. You can bring an attorney on board at any time in the middle of your case. You could switch attorneys at any time in the middle of your case. It is important to realize that if you do switch attorneys, if you have a bad feeling about an attorney, don't work with them. Switch attorneys right away, because the longer your case goes on, when you switch attorneys, you're going to have to get that new attorney up to speed. And the costs of getting a new attorney up to speed are really, really high, because they have to review basically all of the filings in your case, which can get really costly really fast.
Agree. And also to add to that, you can also convert, your representation of an unbundled case to full representation, depending on who you're working with. I have certain cases where I tell the client, look, I can work with you unbundled right now, for as long as it kind of makes sense. And then if you want to switch to full representation because you need more help, you certainly can. And a lot of cases convert that way. So at least for as long as you can carry yourself through your case with some help, you can save all of the cost of that and then switch to full representation if necessary down the line.
Amazing. Thank you. Yeah, we had a couple more questions. Can LLPs appear in court? Yes. We actually answered that one earlier. As of December 1st, an LLP can litigate in a courtroom. Is that correct? December 1?
That's my understanding. Yeah. And up until then, for the next couple of weeks, they can still go with you to court. They just can't. The only thing they actually can't do is actually question witnesses. Everything else with respect to the preparation, attendance, objections, everything else they can already do. So yeah, but after December 1st, they'll be able to go and actually do all of the same functions as an attorney. As long as the issues within the case fall within their scope, then you'll be having a pretty equal footing there at that point.
Yep. We have one more question that I can answer in part, and maybe Ashley can answer. Is it better to have full representation if trying to prove the other party is unfit? So I have experience with a ton of clients and people, that I've encountered that do represent themselves pro se if they're trying to show that the other parent is not a safe parent. There's going to be other lunch and learn events that we're going to have that will deal with that topic specifically, sort of what routes you can go down. There's information on my website as well that talks about sort of how to structure your case. But, it really is just cost dependent. I know parents who have been able to represent themselves pro se to do that. I know parents who have had, unbundled legal service help, and, parents who have had full representation support in those cases. And it really just is a case by case basis. So I want to be mindful of your time, Ashley, and everyone who attended. Ashley, thank you so much. This was so valuable. I know this community is going to get so much out of this. There are so many good ideas and nuggets for how to save money, where to get support and what you can probably handle on your own. Ashley, if you just want to scroll to your contact info at the end so people can take a screenshot of that. Thank you again, Ashley. I just want to let everybody know that due to the Thanksgiving holiday, we will not have another Lunch and Learn. Our next one will be on December 10th about how to write that, perfect parenting plan to dot all those I's and cross all those T's. So thank you so much to everybody who attended. And Ashley, thank you.
Thank you.
And we will see you next time.
Take care, everyone.